Some time ago, I think in September, I accused some judges of the Supreme Court and the Court of Appeal of corruption because they kept insisting that there exists a judgment by consent dated 5th of May 1992 in civil case 1219 of 1992. I have categorically stated there is no judgment like that. The judge who is purported to have recorded the consent, Justice Erastus Githinji, has issued a ruling saying there is no judgment like that. The lawyer who was supposed to have represented me, Mr. G.K. Menye, has also sworn an affidavit and said he has never represented me in any case. So this judgment does not exist. I accused those judges, and then I filed a petition in the High Court to compel them to produce this judgment. To my surprise, I thought they would just publish that judgment in the press, but instead of doing that or filing it in court, they engaged lawyers, and now we are in court. They are trying to prove how this judgment exists without producing it. But I know I'm restricted to talk about matters in court, otherwise I'll be cited for many things. They call them, I don't know, res judicata, jurisprudence, sub judice, things like those. So I will not address that. Today, I'm here to address Chief Justice Erastus, Chief Justice Emeritus David Maraga. Chief Justice Emeritus David Maraga has offered himself as a candidate to be president, to be on the ballot in the presidential elections next year, 2027. And I, as a citizen, I'm a voter, and I have some questions I would like to ask Justice Maraga before he offers his candidature. And I would like to refer Justice Maraga to Civil Appeal Case number 56 of 2012. Civil Appeal Case number 56 of 2012. This matter went before his bench where he was president, and a judgment was delivered on 18th of October 2013. In that judgment, several things were indicated, but what I would like to refer to is the following sentence. The company, that is my company, and the guarantor, that's my guarantor, filed High Court Civil Case number 1219 of 1932 against the bank. On the 4th of May, a consent was recorded in which the company and the guarantor undertook to liquidate the liability, failing which the bank will proceed with the sale. There was once more default, and the bank proceeded to sell the guarantor. Now, as I've said before, and I say it again, this judgment does not exist. And you can see it is the one that was now used to sell my property, a 450-acre farm in Thika, which was valued at 3 billion but was sold at 70 million shillings. And this is the money that has been used over the years to bribe judges to the extent of close to 1 billion shillings. This judgment was as a result because I reported this matter to the police when I detected that indeed there was fraud, and the police investigated the matter, found it is true there was fraud, and forwarded the matter to the DPP, who concurred and agreed that some officials of the bank and the auctioneer should be prosecuted. When these people are arrested, this is what they went to court to contest, and this is what Justice Maraga said. The court restrains the CID from investigating, summoning, or arresting the bank's employees, or investigating any matter in respect of the dispute between the company and the bank. So that is what sealed the fate of my case. He has stopped the police from investigating or arresting, and combined with the fake court order, that is how my case ground to a halt. At that time, the rumors doing the round was that Justice Maraga was bribed with 30 million shillings by the buyers of the farm to tell that lie that an order exists, and also to stop the police from arresting anybody. I feel I should not keep quiet when somebody like that offers himself as a candidate to become the president of this country with such a track record. Somebody who can misuse his office as a superior judge of the Court of Appeal to tell a lie that a court order exists when there is none. Otherwise, it should have been in the record of appeal. Every time you file an appeal, you file something called a record of appeal. And I'm challenging Justice Maraga to show where that judgment of 4th of May 1992, the consent judgment, was filed in the record of appeal. So today, I thought it's appropriate to challenge the good judge to come up with an explanation. Because for a judge to lie, to write a judgment based on a lie instead of evidence, it can only be because of two things. He was either bribed or he is incompetent. And those two grounds, bribery, corruption, and incompetence, are enough grounds for me to use to block his intended candidature to become a candidate in 2027. And I would also like to comment that the same judge, Chief Justice Emeritus David Maraga, nullified the presidential election of 2017. And I know some people who keep wondering whether the above negative attributes of bribery and ineptitude were at play when that judgment was delivered. But I'll leave that question to Kenyans. Mine is to follow up about the injustice that has been visited on me by all these judges over the last 34 years. And I want to promise them, I'm not about to keep quiet. I'll make noise until justice is done and it is seen to be done. Either produce this contested consent order, publish it for the public to see, or admit it does not exist and face the consequences. I have heard that, and I know he is standing on a platform of integrity and zero tolerance to corruption. I don't want to judge him. I have just asked him a question. Were you bribed? Justice Maraga, were you bribed with 30 million shillings to use your office, your high office as a judge of the Court of Appeal, to miscarry justice, to oppress a Kenyan citizen? If you are not, why did you tell a lie that there is a judgment dated 4th of May 1992 in High Court number 1219 of 1992, when, as a matter of fact, no judgment like that exists? And if it does, produce it. Produce that judgment where you saw it. Refer to your record of appeal, and produce that judgment. If it is not there, please explain to Kenyans, was it bribery or incompetence? Why did you write a judgment based on a lie? If Justice Maraga runs for office and he has not answered me satisfactorily, I'll be there, front line, protesting and objecting his candidature. So he had better, and I would like to advise the good judge, don't rush to court and start asking for compensation, threatening me. Just publish this judgment. You have a very effective communication system. I see you on TV all the time. Use the same communication system to publish this consent judgment of 4th of May 1992. Put it in the press, and now we will withdraw and apologize early in the morning before you wake up. La sivyo, nitakuwa mbele, mstari ya mbele kupinga your candidature to become a president.